Our next case is Mount Clemens Rec Bowl versus DHHS. This is also a 15-minute mini oral application, mini argument on the application. You will both have 2 minutes of a free fire zone, which you may waive. And you may reserve time, but we ask that you keep track of your time, please.
Good morning, Your Honors. Justin Majewski appearing on behalf of the appellants. Madam Chief Justice, fellow justices, and may it please this honorable court. Michigan's regulatory takings jurisprudence is in need of an update. This court has not had the occasion to consider the proper application of the Penn Central factors in over 20 years. In that time, the United States Supreme Court has issued several important opinions clarifying the proper scope of inquiry under Penn Central. As it stands, Michigan's jurisprudence does not adequately reflect the fact that the Penn Central inquiry focuses directly on the severity of the burden imposed on private property rights, or that the primary factors under Penn Central are the severity of the burden, the burden imposed on private property rights and the interference with investment-backed expectation factors. In this case, the Michigan Court of Appeals failed to weigh the primary factors, instead relying entirely on the analysis in the Gym 24/7 fitness case. This in itself was a critical error because the Penn Central analysis requires case-specific factual inquiries. Compounding this error, the Gym 24/7 fitness case failed to properly weigh the factors, holding that there was no taking despite the fact that both of the primary factors weighed in favor of the taking. Michigan's regulatory taking procedure is also in need of this court's intervention. Michigan's takings clause requires that just compensation the procedure for determining just compensation be determined according to statute, and that includes whether it should be tried to a judge, jury, or otherwise. While Michigan does not have a statute specific to regulatory takings, it does have the Uniform Condemnation Procedures Act, which states that it applies to all exercises of eminent domain, and it also provides a jury trial right on the issue of just compensation. The Court of Appeals in this case held that neither the UCPA nor any other statute applied to regulatory takings questions. This court should take this opportunity to bring Michigan's regulatory takings law up to date. I welcome the court's questions. Appellants asked this court to adopt the rule stated in Lingle v. Chevron with respect to how the Penn Central factors should be applied. Again, under Lingle v. Chevron, the focus is directly on the severity of the burden imposed on private property rights, and the primary factors are economic impact and the interference with investment-backed expectations.
Counsel, good morning and Happy New Year and welcome.
Thank you.
What would happen if one of your clients were to violate this order?
There were law enforcement penalties associated with these orders. My clients were also threatened with by the Liquor Control Commission to basically take away their liquor license. So there were several dire consequences threatened by the state with respect to whether they complied with the order.
So this was pretty intense. If you violated this order, you lose your liquor license, you could go to jail.
That's right.
Okay,
Yeah.
thank you.
Welcome.
Counsel, you obviously argue that your client is more burdened than others subject to this order. I have to say, my impression from the outside is that the food service industry actually was able to keep operating. They did a lot of takeout business. I'm not saying there wasn't an economic hit, of course, but to say they were more burdened than others feels like a stretch to me.
Thank you, Justice Walsh. So with respect to the orders, there were those implicated in the orders certainly were affected much more than those who were not implicated by the orders. So there's a singling out by just being included in the orders. But taking it a step further, the appellants in this case are small family-owned businesses. They're dine-in businesses. They're not equipped to handle their entire business volume being takeout only. They don't have drive-through windows. So while a restaurant like McDonald's might have had no problem adjusting, my clients had essentially no economically beneficial use of their property. They
Isn't
tried.
it true that isn't it true, Counsel, that when most people come to a restaurant, they're not going to consume alcohol to go? So isn't it true that for the restaurants that you represent that have liquor licenses, the vast majority of their profits comes from the consumption of alcohol? And when you switch your model exclusively to a takeout model, it's very difficult for restaurants such as that to break even. Also, is it not the case, this is just kind of a follow-up to the question you just answered, is it not the case that people, when they want to go to a restaurant, they don't want to use plastic silverware, they don't want to use styrofoam? If I'm going to go for high-end dining, why am I going to spend $100 to go to a high dining facility to use it on plastic silverware or, styrofoam cups and things of that sort? So isn't the argument that, well, you could switch over to carry out really kind of a deficient argument, because ultimately most restaurants really couldn't survive on that?
Justice Bernstein, I would agree with you. I think that's a great point. And I think those questions are interrelated insofar as, yes, we definitely lost a significant amount of profit through the inability to sell alcohol, or at least at the level that you would be able to with dine-in service. And it's about the experience. A lot of people, we have regulars who come in and they want to spend time in the restaurant. They want to get out of the house. They want to, it's a night out. And so you lose that with takeout service. It's just not the same. And so I was also struck by a question that you had asked my brother counsel with respect to gyms, as far as needing to switch their entire model because you lose that ability to come into the gym facility. It's sort of similar here, where you get people to break their routines. People who were regulars that frequented these business establishments over and over got into the habit of going out maybe on a Friday night. These orders broke that routine, such that years removed from these orders, these businesses have still not recovered. They're maybe at 60% of what they used to be. So there's been a significant reduction in value for these businesses as a result of that breaking of that habit.
Counsel, I'm looking at the Court of Appeals opinion, and it doesn't appear to me that the Court of Appeals in your case ever really weighed the Penn Central factors. Am I missing something?
No, I don't think you're missing anything. They relied basically on Gym 24/7, but never really applied the factors specifically to our clients.
So I think the Court of Appeals said the only different argument is that you are contesting whether the regulations were warranted. But then in what I consider to be a very bizarre assertion, the court said that the gym case is binding case law regarding how to view the COVID-19 regulations in Michigan. How should we interpret that phrase?
I agree with you. That does seem like a bizarre statement. And part of the
all
problem
executive orders, 140 or so by the governor, all executive orders by the DHHS, the gym case is binding precedent on all of those which weren't considered in that case? That would be...
I agree with you that I don't think that should be the case, particularly under the recent regulatory takings case law announced by our Supreme Court. The focus is on the property. What was the economic impact on the property? What was the interference with distinct investment-backed expectations? And so you shouldn't be focusing on how to view the orders. It's how did those orders affect the specific litigants that are before the court? And that's why there is the requirement that there be case-specific factual inquiries in every regulatory takings case. You can't dispose of these takings cases on general propositions, and that's established law. And for that reason...
Your client wasn't permitted to do any discovery in this case?
No, this was a pre-answer motion to dismiss.
And what type of discovery would you do, or would you need to do?
Well, we would certainly want to have, maybe less than discovery, but you'd certainly want to have an evidentiary hearing where we can have witnesses testify. You want to get evidence on the record regarding what were these.
But this is a C8 we're talking about. You don't get an evidentiary hearing for C8. What kind of discovery would you want to get past the C8?
Your Honor, we would not need any discovery to get past the C8. Excuse me if I misunderstood the question. I thought the question was to analyze Penn Central. What kind of discovery would you need? But for the C8 motion, certainly we wouldn't need.
But even on the Penn Central factors, if we were to conclude the analysis was not thorough enough, and that at least the last council asked for discovery, Justice Viviano asked, what type of discovery would you do for Penn Central? An evidentiary hearing to me is not discovery, so you didn't answer his question. I was trying to get you to focus in on his question of what type of discovery would you need to then be able to say to the court, here's why I should be able to proceed on the Penn Central factors as opposed to a dismissal off the pleadings.
Thank you, Justice Zara. It's our position that we shouldn't need to present any sort of evidence on a C8 motion. Only the pleadings can be considered. However, if this court were to determine that there would be some evidence needed at this stage in litigation, we would at least like to be able to submit affidavits from our clients in terms of discovery to.
I mean, let's reset my question here.
Sure.
Your position is that the case can't be dismissed based solely on the pleadings. Instead, you should have been allowed to do discovery. I'm sort of stepping ahead and saying, okay, if we ruled in your favor, what type of discovery would you need to do to make your arguments on the Penn Central factors and help us understand whether the lower courts are properly balancing those factors? It seems very difficult for us. The Supreme Court has given no guidance on how the factors are to be balanced, and courts have struggled with that throughout the decades, and commentators have commented on that throughout the decades, and now we're struggling with the question of how they should be balanced. Should we just summarily dismiss these cases, say they relate to COVID, other courts have dismissed them, all COVID's the same, that's a big deal, and you lose? Or should we think in a thoughtful way about how to apply the Penn Central factors and what evidence might be needed so that then we can have an intelligent discussion about how to balance those factors?
Thank you for that
and how
clarification.
to weigh them.
Yes, we certainly feel that there needs to be, we need to have the opportunity to be able to put forth evidence relevant to the Penn Central factors themselves. So how severe was the burden on our clients? We need to be able to submit evidence, be it business records, testimony through affidavits or otherwise, to show what that impact was on these businesses. What were the investment-backed expectations? What investments were made? When were those investments made? And what were the expectations at those times? The character of the government action factor, that is more focused on, whether the regulation itself spreads the burden out, proportionality, whether there's an average reciprocity of advantage provided. But certainly as to the first two factors, the primary factors, we would like to be able to submit evidence to show how these regulations impacted our clients. And I don't think you can have a satisfactory Penn Central analysis without that.
In Penn Central itself, I haven't read that case for a little while, but it seems to me that wasn't decided on the pleadings, was it? When we were talking about the airspace over, was it Grand Central Station in New York?
I don't know if that was, I certainly, I don't know that the opinion was clear, but I don't believe that it was on the pleadings alone. And I know in reviewing the case law on this issue, it's very rare for a Penn Central, or rather a regulatory takings claim to be dismissed on the pleadings. Basically, before COVID, it hadn't happened. And so it's sort of an unusual result to see these cases dismissed before there's been any factual development whatsoever.
Counsel, how do you get past the Prohibition era cases, which clearly resulted in lots of businesses not being able to put their property to its best use, and it was still not deemed to be a taking?
I'm sorry, I think I missed the first
The
part of that
Prohibition
question.
era cases, where alcohol was no longer allowed to be given for sale, and obviously these businesses, their primary business use was eventually rendered useless, and yet those were not deemed takings.
In the other jurisdictions that have considered this issue?
Our state, federal law, yeah.
So I think that a lot of the lower court decisions that we've seen have been incorrectly applying the precedent that we've had from the Supreme Court. I think looking at Lingle, certainly, as Justice Viviano stated, it doesn't provide a tremendous amount of guidance, but it provides the most guidance of any case before it or since as to how you should weigh these factors. It also clarifies the difference between a due process inquiry and a takings inquiry, where due process is concerned with the government's purpose and whether that purpose is being furthered by the regulation, and that gets to the ultimate point of whether that's a valid regulation, whereas takings are concerned with whether the regulation impacts the property to the point where compensation is required. The
Right,
federal
and certainly
law-
those cases, the property was very impacted. Alcohol no longer could be sold. These were businesses that made alcohol for a living, and they had equipment. That is what they were designed to do, and yet courts said, not a taking.
And so it's our position that those courts misapplied the standards, specifically as it relates to the character of the government action factor. That factor.
So wouldn't that argument, I mean, every government regulation then that restricts property and then affects the bottom line is a taking? Is that your argument?
No, Your Honor. My argument is that you have to balance the factors. So if you have a regulation that slightly burdens property rights and perhaps doesn't interfere with investment-backed expectations, then that would not result in a taking. But these regulations, I believe my time has expired.
Yeah,
May I
go ahead,
briefly
yeah.
conclude? These regulations just went too far. They took too much, and they lasted for far too long, and that's the difference between some of the past precedent from the Supreme Court and the application of these factors to this case.
What would have been the right amount of time? If this was too long? 1
Cer-
month shorter, 2 months shorter?
I wouldn't say that there was a right amount of time, but what would be the amount of time that maybe wouldn't result in a taking? That, again, will be determined by factual development
So
regarding.
it's different for every business?
That's right, and it's different you have to balance it against the impact on the business. So you look at how bad was the impact, what kind of investment-backed expectations were there, and then you balance it against the length of the.
So it could be 1 week for one business and a year for another?
I would, yes, I'd say it's totally dependent on the facts of the case and on each litigant. And it's determined, as far as the length, determined on, what the actual restriction is. So if it's total deprivation, a shorter amount of time would weigh in favor of taking. A lesser restriction probably would require a longer period of time. Thank you, Your Honors. Appreciate your attention. Thank you.
Round two.
Back again. Good morning, Your Honors, again. May it please the Court, Solicitor General Ann Sherman, on behalf of the state defendants, with me at council table, still here, is Assistant Attorney General Darren Fowler. This takings case, unlike the last case, does have a threshold jurisdictional question, and just addressing that briefly, the plaintiffs here have no statutory or constitutional right to a jury trial. And so absent that, this case, the claims here fall squarely within the jurisdiction of the Court of Claims. On the merits, as with Jim 24/7, the best resolution in this case is the doctrine of necessity, and it removes this inquiry from any of the takings analysis. There is no right for a business that, even though it has vested property rights, to be able to continue to operate when the state has acted and exercised its police power in a grave emergency. And again, this court has already acknowledged that this COVID-19 pandemic is one of the most threatening crises, public health crises in modern times. If the court gets to the takings analysis, these parties agree that Penn Central is the test. And under that flexible test, there's no taking here. Every factor, properly understood, supports that conclusion, and no amount of discovery would change that conclusion as a matter of law. I want to address a few points that we've talked about with respect to police power. And Justice Welsh, you asked about, you brought up the prohibition cases. And those are cases that are police power cases. So they would, they would fall under the doctrine of necessity, and it would take this completely out of the takings analysis. And that's where the court's thought should be. It's the best appropriate way to analyze this case. When you look at Mugler versus Kansas, that was the prohibition on the use of the building as a brewery. Best way to use a brewery, but the court said no, that the state can't be burdened with the condition that it has to pay to prevent injury to the community.
But counsel, good morning again. I love when you come to our court, but isn't that completely distinguishable from what we're talking about here today? Because when you look at these prohibition cases, ultimately, this was a major issue. Congress debated, discussed it. This was like a whole different kind of a situation. It was deemed to be dangerous and illegal, which is different from the COVID situation where all of a sudden you're basically told as a restaurant, you're done, close it down. Everything has to be modified, has to be changed without any notice. If the government determines in a prohibition matter that, ultimately the sale of, this was way back, but the sale of alcohol is equivalent to like a dangerous drug, isn't that a completely distinguishable argument and distinguishable issue from the notion that in this situation, all of a sudden, you can't operate your business, you can't allow your business to function, your entire model has to change, period, end of story. So you can't really use those cases to really argue that it's kind of analogous to what's happening with what the state did with these folks, can you?
Well, I respectfully disagree. We're talking about the alcohol cases.
Right.
People versus Everly, you have the prohibition on the sale of alcohol, and that rendered the plaintiff's inventory valueless. But the court cited health and safety and used the police power and took that right out of that was not any sort of a balancing. The court said, even though it rendered your inventory valueless, there's still the government can do that in an emergency. And again, this is at the heart of the police powers. There's been some conversation here about the weighing of the Penn factors. And although I think the best resolution of this case is the doctrine
Counsel, before we get to that, you brought up the jury trial thing, so this is going to come out of left field for the audience, but I think you'll track with it. My question is, what should we make of the plaintiff's argument that that Hill was wrongly decided, the Hill case, which I think you're relying on, based on the language in the Northwest Ordinance, which is a couple centuries ago, 1787, Section 14, Article 2, stating that no man shall be deprived of his life or property, but by the judgment of his peers or the law of the land. What should we make of that argument? That language seems pretty clear that it requires a jury trial in a takings case. Am I wrong?
Well, I think, respectfully, there is no constitutional right to a jury trial, and there's no reason to revisit Hill on that issue.
Well, the question is whether there was a right to a jury trial for this type of claim under our Constitution when the state was formed, I think. Is it not? Because that right was then preserved by each succeeding constitution. Is my legal analysis off the mark somehow?
We say that a general right to jury trial remains, but when you look at the takings case, the takings clause, and you have to read the Constitution as a whole, it's significant that the 1908 Constitution had a limited, constricted right to a jury trial only for necessity and just compensation. And then you have the removal of even that constricted right to a jury trial in our current Constitution. The fact that the 1908 Constitution even had to address the specific constricted right to a jury trial in the takings arena shows that a general right to a jury trial isn't sufficient. We looked at that differently. We read the Constitution as a whole, and we look at the fact that it's significant that there was only a constricted right. It was specifically mentioned in the takings clause, despite the general right to having a jury trial remain, and then we removed it, and our current Constitution doesn't have it.
I get your point. You think the constitutional language overrides apparently the Northwest Ordinance.
Yes.
Fast forwarding back to Penn Central, and I'm really interested to hear what you're going to say about how we should balance those factors, but before you do that, can you help me understand? I was looking back at Penn Central to try to refresh my recollection, and it seems to be pretty fact-intensive, looking at the records, the facts in the record about different investments, expectations of the property owners, and so forth, and analyzing those factors on a pretty extensive record. And there's law, pre-COVID law, that says, yeah, that's a fact-intensive inquiry from the Supreme Court and from the Federal Court of Claims and other places. But you're here telling us, not for COVID, not fact intensive at all, at least not that you need to go beyond the regulation itself. Can you help us understand what class of cases, Penn Central cases, you believe are not fact intensive, or at least don't need discovery? Because, you know, are we altering all Penn Central cases from now on, or are you just saying this is a special, sort of, we're in the glow of COVID, and so these have to be handled differently, but after this, we'll kind of reset back to the normal lane of Penn Central?
I would agree with you that all cases say this is a fact-intensive inquiry. The question is, what facts matter to the takings jurisprudence? And again, when you look at like the ad hoc flexible test, you're looking at what facts matter to be able to look at and evaluate those factors. And there are cases that would require a factual record, but it does not here. Most cases that you look at with takings, especially where you find a taking, you're looking at one business, one house. You're not looking at a widespread regulation where there would have to be discovery for here, potentially 17,000 businesses. I mean, the complaints, the factual allegations.
The problem also the fact that the Court of Appeals presumed that the first two factors actually favored the plaintiff, right? And so the question is this third factor and perhaps how you weigh them, but the question to me is what facts could be developed, assuming the first two already favor plaintiff, what could be developed in the third factor that would change that analysis?
Well, my answer would be none. That yes, there are facts that could be developed, and they will be developed during discovery ad nauseum for potentially 17,000 businesses that plaintiffs say have food and beverage licenses in Michigan. But the point is not whether facts could be developed, but whether what facts are needed to be able to, for the court to be able to engage in this inquiry. And when I say the facts that are needed are in the EOs, I say that because you can link what's in the EOs to the factors. When you look at the burden and the allocation, we know that the burden was to one strand of their use, which was public access. We know that all the other bundle of rights still remained. We also know that the allocation was to all similarly situated food and beverage establishments, and that also there was a significant burden on many other places of public accommodation, including the gyms, the bowling alleys, the casinos, the non-invasive, the non-emergency personal services, the places of amusement. That's how we know the burden was proportional. And when you look at even Lingle that talks about sort of this weighing.
Let me just jump in, because Justice Kavanaugh was talking about the court assumed the first two factors benefited, in the gym case at least, benefited the plaintiff. But then it gave it sort of short shrift because they said the economic impact was short-lived. Well, gee, if I was one of these businesses and if I had long-lasting impacts, or if I filed bankruptcy, if I lost my entire business, if I lost half my customer base, businesses have struggled for years. I just read the newspaper that 50 more restaurants in Metro Detroit just closed down last year. And so wouldn't I want an opportunity to say, hey, hold on a second. I have some facts, some evidence to show that these economic impacts have not been short-lived. So even as it relates to the first two factors, and we're supposed to weigh all three of these factors, and we still don't know how to do that, but to say, yeah, these are in your favor, but they don't really matter very much. I mean, that might not sit well with me if I had just filed bankruptcy.
I am not unsensitive to the economic impact, but when we look at takings jurisprudence and we're looking at how much this business lost and how much this business lost, we're talking in part about sort of business decisions, and all regulations from the government are going to affect businesses in different ways. But when we look at the takings jurisprudence, what we're talking about here with the gradations in how these businesses were affected, we are generally talking about lost profits and revenue. And in the grand scheme of the bundle of rights in takings jurisprudence, that is a slender reed. That's what Andrus versus Allard said, the U.S. Supreme Court. It's what many cases, College Saving Bank, U.S. Supreme Court said business in the sense of the activity of doing business or of making a profit is not profit in the ordinary sense. Is not property in the ordinary sense. And when we're looking at takings, we are looking at essentially looking at property. It's more of an in rem proceeding. Our state law
I think, by the way,
encompasses.
all these arguments you're making are very interesting, and I don't know how this case comes out or would come out if we send it back for discovery. But it just seems to me that we're deciding in the modern era now which sort of types of claims are favored enough to get discovery. We just sent a workers' comp case back for discovery or the pleadings. I couldn't understand how the person could possibly make out a claim, but we sent it back for more discovery. Other cases, less favored cases, get no discovery. The parties came before us on a redistricting case, and on the pleadings, we dismissed the case, original action in our court, and said you didn't present enough evidence, which I found perplexing at the pleading stage. I'm just wondering, why aren't we having these interesting debates in the ordinary course of a lawsuit after the plaintiffs have discovery, and then you can raise all these arguments, which I think are, some are very strong, and may at the end of the day carry the day for the state. I'm just wondering why we're having that conversation now. What makes this case so special that it shouldn't be treated like every other?
Because plaintiffs don't get discovery that would not change the outcome of the case based on what we know now with the factual scenario. We know about the allocation of the burden in terms of investment-backed expectations. We know from case law that a business can't obtain property rights and then expect that they will be free from the police power.
Looking just at Penn Central, how can we possibly know enough about the economic impact on the plaintiffs to do the analysis that the Supreme Court did in Penn Central, where they went into detail about the economic impact of the regulation on the plaintiff in that case? I just don't understand how we can
What
do
we know is that these businesses had a temporary shutdown, not a temporary shutdown, just a temporary restriction on use. And
I know, but you don't know how it impacted them. You couldn't unless you have their, tax returns and all their economic data. What you're here telling the court is COVID was a big deal, so we went on the third factor, no discovery. Isn't that basically your argument?
respectfully, you can look at the executive orders and see that the impact was to public access, and that when you look at takings court jurisprudence, may I finish? When you look at takings court jurisprudence, you see that lost profits, that doing of business is a small strand in the bundle of rights that those businesses have. And that is enough to have that Penn Central factor answered without discovery. Looking at the investment-backed expectations, these businesses didn't have the right to continue to operate in the face of an emergency, and they could never have expected that.
I mean, as usual, you're doing outstanding. Just the usual question that I asked in the last case, but really what it comes down to, and that's just my thing, to keep it simple, and it's going to be the same question that we got in the other issue, the other case. But really what this comes down to is, at the end of the day, the argument is that the executive can make a determination that you are going to be shut down, and ultimately, from the argument that you're putting forth, a restaurant owner, a mom and pop shop, basically really has no recourse at the end of the day. And your argument is that they shouldn't have the opportunity to present to a court of law how this impacted them, what challenges they had to face, what effect this had. Isn't that really kind of what we're saying, just to keep it simple, that ultimately a decision is made and that's it? And for all intents and purposes, you're going to have to shut down, maybe you can do carry out, and ultimately what your argument is, hey, if that's the case, just like with the gym case, if there's even the most minute way that you can use the property, you're not going to be entitled to compensation. Not only are you not going to be entitled to compensation, but you're not even going to be entitled to have your day in court to basically put on a case to show why compensation should be allocated.
Respectfully, Your Honor, these plaintiffs do have other recourses. We are looking at whether they have a recourse under the takings clause. There are other resources like due process claims. There might be non-judicial recourses to the harm that they suffered, but we're looking at the economic profit, the use of their land not being a very big strand in the bundle of rights that a property owner has. And that's as our state court has said, the takings clause doesn't guarantee property owners an economic profit from the use of land. So as much as that would have been an impact to them, under the takings jurisprudence, we don't have to look at every business and say, here's what this particular business lost exactly. What we know is that it was the process of doing business and the profit making, and they still had in their bundle of rights enough rights to satisfy the Penn Central test.
Thank you, Counsel.
Thank you, Your Honors.
Thank you both. The case will be submitted.